In this module, we're going to discuss working with experts. Working with experts begins with a search, and when you find an expert in the field you think is appropriate for your case, he or she may not be available or the proper expert for the consultation you seek. You should feel free to ask that person to direct you to other experts in the field who might be more appropriate, or even other fields that you might not have considered when you searched for a particular expert in a particular niche. When you find the expert that you want to work with and who has agreed to work with you on this case, determine what type of expert you're looking for. In general terms, there are two large categories for how an expert is going to fit in to a case model. One expert is called a framework expert, who sets out general evidence about a set of medical or scientific conditions that affect a class of individuals. The other type is an evaluating expert, someone who will examine or test a single individual to determine whether that person's specific situation or condition or trait or illness meets a particular legal standard. For framework experts, the task is a little simpler. The attorney or whoever is engaging the expert in the case will present the context and the issue to the expert, who's going to speak in general terms about a scientific phenomenon. Let's take adolescent and emerging adult brain development, for example. The framework expert would give a general overview of normal neurologic development, speak about what changes occur in the brain and how they relate to behaviors, and give age ranges for when those are relevant considerations. Those will overlap with considerations in the case, and the framework expert will stop there. They speak to the characteristics of a group of which the particular defendant or plaintiff or respondent is a member. For individual evaluators, the task is more complex. The evaluator is going to have to examine the individual at issue here and determine whether the subject meets a threshold set by the legal standard in the jurisdiction. So, for example, whether a defendant meets the legal standard for lack of capacity, inability to conform their conduct to the requirements of the law, or whether this specific person was harmed by a toxin or an accident or a condition of the business that he or she works in. When you're working with expert evaluators, you should follow some important guidelines. First, try to choose an expert evaluator who's been hired by both the prosecution or the defense on cases or by plaintiffs and respondents in the field, signaling an independence or a lack of partisanship which gives authority to that expert. Build trust and mutuality with your expert. This means some very important steps. The first one is to be honest and forthright about your theory of the case. There should be no surprises. Provide all data that the expert requests. Don't cherry pick, don't skew the data in your favor. Holding back what you consider to be negative evidence is a promise of disaster for the future. Third, prepare the expert thoroughly about the proceedings. Don't assume that all experts know the rules of law in the jurisdiction or the restrictions on the forms of testimony or communication. You need to communicate your field to them as they are communicating their field to you. So you need to prepare them for depositions and direct testimony. What is that going to be like? How should they prepare for this? What are the rules of those settings? Anticipate cross-examination and prepare for that with your expert at length. Instruct your expert about the ways of the courtroom, because the ways of the courtroom differ from the ways of the rest of the world. How should they relate to the judge? How should they relate to the jury? Provide instruction on specific procedural rules that are unique actually in that specific jurisdiction if it's outside where the expert actually practices. Explain the extent of attorney-client privilege to that expert so that expert doesn't inadvertently undermine confidentiality and privilege. For example, by using emails to communicate with subjects or with the attorney in an unprotected way. Introduce your expert to the local customs and the local mores, which should be honored. That helps an expert actually relate to members of the jury and the public in a more respectful and intimate way. And finally, this is very important, respect your expert's opinions and the limits of that opinion. If they've carefully examined all of the evidence and they've read all of the records and they have done collateral interviews and interviewed the subject at hand and do not agree with your conclusion, listen and determine why. You only want an expert who can vigorously stand by their opinions ethically and precisely. So if the expert disagrees with you, honor that disagreement and either see what that expert has to offer, or if permissible within the case, choose a different expert. Thank you for being here with me today.